Apologies, John Powers on behalf of plaintiffs.
Good morning. I'll take the appearances for the defendants' counterclaimants.
Good morning, Your Honor. Anne McCready of Taft Law, and I'm joined by my co-counsel, Devin Sritarana of May Potenza.
Good morning. And let's see, we have Mr. Stapleton. Go ahead and make your appearance.
Morning, Your Honor. Warren Stapleton appearing on behalf of Michael O'Donnell.
Good morning. And Mr. Sheehan, do you want to make an appearance?
Yes, Your Honor. Dale Sheehan on behalf of Gallagher and Kennedy.
Okay. Good morning, Mr. Giles. Do you wish to make an appearance?
Yes, Phil Giles, Bankruptcy Counsel for Assetor Global Technologies. Thank you.
Okay. Good morning. Is there anybody else who wishes to make an appearance who I did not already hear from? Hey, I don't hear any other appearances. We do have a court reporter present with us. We're also making a record of the proceedings through the FTR recording. So let me first of all inquire who it was who made the arrangements with the private court reporter.
That was requested by us, by the defendants.
Okay, and so the defendants have made the financial arrangements to have the court reporter prepare the transcript?
Yes, that is correct.
Okay, and before I administer the oath to the court reporter, let me remind you, Ms. McCready, that the official record will be the FTR recording unless you have the transcript prepared and you file that transcript with a request and a proposed form of order for the court to adopt the court reporter's transcript as the official record. So I just want to make sure that you're aware of that step.
Thank you, Your Honor.
Okay, let me have the court reporter confirm, please, that she is willing to abide by the requirements under Arizona Supreme Court Rule 30 with respect to timely preparing the transcript if requested by the defendants. And I think you're muted. And
I will.
okay, thank you. Let me have you raise your hand, please, your right hand, and take the oath. You do solemnly swear that you will take down in brief form the evidence and proceedings in the case now before the court and thereafter transcribe the same if required and otherwise perform the duties of the court reporter in this case to the best of your skill and ability, so help you God?
I do.
Okay, thank you. You can now go ahead and mute yourself again. Okay, let me take up next the emergency motion to continue hearing on motion for attorney's fees. It was filed by Mr. Powers this morning. And I did not receive any written response to that, although it was my understanding that the other parties, at least somebody has indicated that they oppose continuance of the hearing. I've been advised of that by my staff. So the motion indicates that Mr. Hopkins received a medical diagnosis about 30 days ago, about a month ago, and there's some sort of inability to communicate with Mr. Powers as a result of that. But that diagnosis came in 30 days ago. We just received the emergency motion this morning. And today's hearing is oral argument, not an evidentiary hearing. So Mr. Hopkins' participation is not going to be required today. And the briefing has already been completed on the motion. So for all of those reasons, I'm going to deny the emergency motion to continue, and we'll proceed with the oral argument today. This is the time for oral argument on the motion to dismiss pursuant to Rule 41A2, the motion for sanctions under Rule 11. There is a motion to strike with respect to the Rule 11 motion and also argument on the motion for an award of attorney's fees and costs. Let me start with the motion to dismiss. And let me just address the procedural posture of the case. I previously granted the defendant's motion to dismiss the plaintiff's claims. The only thing that is remaining are 2 counts of the counterclaim. And in the motion to dismiss, the defendant's counterclaimants are seeking to voluntarily dismiss those counterclaims so that we can proceed to a final judgment. And there is no opposition. The only issue before the court at this point, other than dismissing those counterclaims, is the request for Rule 11 sanctions and the request for an award of attorney's fees. So I'm going to go ahead and grant the voluntary motion to dismiss the remaining counterclaims. And I'm going to direct the defendants to lodge a proposed form of final judgment that should have in it blanks for, as required under the applicable rules for any award of attorney's fees, and we'll be addressing that in a moment. So, Ms. McCready, how much time do you need to prepare a proposed form of final judgment and lodge that?
I would expect we could get that prepared relatively quickly, within the next couple days, certainly by early next week.
Okay, so if I gave you a week, that would be August 26th. That should be sufficient time.
Certainly. Thank you, Your Honor.
Okay, I'll direct the defendants to lodge a proposed form of final judgment by August 26, 2026. So now that's going to take us to the motion for sanctions and the motion for attorney's fees. And I'm just going to hear argument on those motions combined together so that we don't need to address them separately. I have reviewed the entire record, so there's no need to regurgitate everything that's in your motions. The motions, the remaining motions for sanctions and for attorney's fees are the defendant's motions. So, Ms. McCready, I assume you're arguing those motions?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. Well, as you indicated, I will try to be succinct with respect to these motions. They were filed together, all 3 of these motions, because they share one origin. This is a case that was built on a false premise and kept alive for more than 2 years by false allegations that ended where it should have ended in May, when the court dismissed with prejudice all of the plaintiff's claims against these defendants. So at this point, what we're effectively trying to do is put the entire case behind these defendants and seek the fees that they've been burdened with along the way. And I need to note at the outset that plaintiffs failed to timely respond to any of the 3 motions. On all 3 motions, their responses were due August 4th. And instead of filing those responses timely, they spent those following weeks emailing me repeatedly, during which time, unfortunately, there was no mention of the health issues that we discussed earlier. So all of the submissions were untimely. And in addition, instead of filing a response to the motion, to the Rule 11 motion, which they did not respond to at all, they filed a motion to strike instead. So I'll come to that in a moment. And I'll address why that's important. But on this record, the Rule 11 motion is unopposed, and the request for fees is subject to waiver for a host of reasons. So turning first to the attorney fee motion, or the fee motion, as an initial matter, the late response does not challenge the substance of the fee request at all. Plaintiffs did not argue about the applicability of the statutes or the merits of the board defendants' arguments. They did not challenge the reasonableness of the fees that we've asserted in our supporting affidavits. The plaintiffs only argue that the motion is either too early or too late. All other arguments have been waived, and they're wrong about the 2 arguments that they did make. Plaintiffs argue we should have moved for fees sooner, but the court was very specific in its May 5th ruling that it would defer the fee determination until the counterclaims were resolved. We simply followed the court's instruction in that regard. Or plaintiffs claim we are too early. Plaintiffs misread Rule 54G3B, which sets an outer deadline 20 days after final adjudication, which there has not yet been, but it does not bar a fee motion filed before judgment on all the claims. Either way, we filed this motion at the same time that we filed our motion to dismiss, which the court has addressed, meaning once that motion is granted, all of the claims are resolved. This motion appropriately can be considered, and we just did it all at once, like I said, for the sake of efficiency, because all of these motions are so intertwined. Beyond those conflicting arguments about the timing of the fee motion, plaintiffs offer no other argument. And because plaintiffs completely failed to address the merits of the request for fees, those arguments are waived. But I'll briefly touch on the reasons that fees are appropriate under the applicable statutes, focusing on 12341.01 and 12349. 12341.01 permits recovery of fees in an action arising from a contract, which this case is. All of plaintiffs' claims fundamentally center on Asator's amended operating agreement entered into in 2023. All of the claims have flowed from that agreement, which resulted in the formation of the board. These 4 defendants were members of that board. 2 of them are no longer on that board, but at the outset of this case, those 4 defendants were members of that board of managers. And this entire case is about whether the board complied with that agreement, whether the board was properly formed, whether the board can do what it has done under the terms of that agreement. And even our counterclaims stem from the same fact. These compulsory counterclaims that we had to bring here, particularly when it comes to our abusive process claim, are based entirely on the plaintiff's litigation conduct and the conduct that led to the formation of the board. So this is a situation where all of the claims are so interwoven and overlapping that the entire case is one arising out of contract under ARS 12341.01. And I would refer the court to Modular Mining Systems, Inc. versus Jigsaw Techs, Inc., which is 221 Arizona 515, where the court affirmed an award of the full amount of the fee request when all of the claims were so interwoven. The board defendants are also the successful party on all the claims brought by plaintiffs, and in fact, all of the filings to date, essentially, based on the court's May 5th ruling, which was an adjudication on the merits of all the claims against these defendants. The board defendants have been successful on almost every single matter that has come before this court, with the sole exception of the dismissal of the board defendants' fiduciary duty claims. And again, the counterclaims that were filed by these defendants are simply the counterpoint to the plaintiff's claims. If not for plaintiff's pursuit of this litigation, the board defendants would not have brought them at all. Dismissal of the claims against the board defendants is a victory for the board defendants, since that was the essence of their claim against plaintiffs all along. And the board defendants also satisfy the other factors identified in Associated Indemnity Corp. Warner, including the fact that this case has lacked merit from day one. And the board defendants informed plaintiffs and their attorney of that fact before they ever even filed suit. This entire mess could have been avoided if that warning would have been heeded. And it certainly could have been curtailed if plaintiffs would have heeded the additional warning that we provided 2 years ago in August 2024 in a Rule 11 letter, or the additional warning that we provided earlier this year in an additional Rule 11 letter. At every turn here, plaintiffs have been undeterred by the complete lack of merit of their claims, and they have pressed forward. There's no evidence before the court that plaintiffs will suffer hardship. They didn't present any argument along those lines if the board defendants are awarded their fees. Plaintiffs have made it clear from the outset, and they tested under oath, they believe litigation is a good way to frustrate Asator's board. And they spent 2 years testing that theory. And while they were unsuccessful on the merits, they certainly accomplished the goal of causing incredible financial burden to the board defendants, and the board defendants should not be required to bear that burden. This final point is also relevant in the analysis under 12349. Plaintiffs' claims here were without substantial justification from the outset. They remained that way throughout the entire duration of the case, and yet these plaintiffs have multiplied these proceedings at every turn. We have detailed at length, and so I will not regurgitate, as you indicated, all of the demonstrably false allegations maintained across 4 successive pleadings, including the allegations that were detailed with exhibits, with documentary evidence in 2 unanswered safe harbor letters, where we attached and cited evidence proving the falsehoods, going well beyond what we can do in a Rule 12 motion to try to give these plaintiffs the opportunity to correct course. We have also engaged in numerous meet and confers to talk through plaintiffs' claims. That's the whole purpose of that process, to try to explain to them that their claims were factually baseless and without merit. Plaintiffs have demonstrated an incredible willingness to stay the course despite these multiple warnings and in the face of evidence disproving their claims, sometimes in the face of their own sworn testimony. Even the court tried to warn plaintiffs in its August 5th, 2024 order, instructing them not to refile claims that would suffer the same fate as those being dismissed at the time. The plaintiffs did exactly that in their third amended complaint, and those claims were yet again dismissed. This is precisely the type of behavior that 12349 is intended to curtail. And finally, as I said, there's been no objection, there's been no dispute of the reasonableness of the amount here. We have submitted declarations from myself and from Mr. Sricharana of May Potenza documenting the fees incurred by the board defendants as individuals and confirming their reasonableness over the 28 months that this case has been pending. Plaintiffs have not said otherwise. There's just no dispute at all on this point. The number is high, but this litigation has been involved, as this court well knows. There have been 4 dispositive motions, multiple oral arguments, expedited discovery, a petition for a receiver, and a 2-day evidentiary hearing. So that lands us at a total of just shy of $800,000 in fees and about $17,000 in costs. And obviously, with the responsive briefing and plaintiffs' multiple email inquiries, those numbers have gone up again, and we can provide the court with updated figures following this hearing. So the request in this motion is an award of those attorney fees and costs jointly and separately from plaintiffs and their counsel. And that brings us to the motion for sanctions under Rule 11, which serves as yet another basis to award the board defendants their fees in this case. And again, as I indicated, this motion is unopposed. Plaintiffs did not file a response. Their belated motion to strike does not substitute for one, and it fails on its own terms. Motion to strike was untimely, but it's also procedurally improper. Rule 7.1F permits motions to strike only when expressly authorized by statute or other rule. Plaintiffs identify no such authority for striking a Rule 11 motion, and under Engel v. Landman, such motions are disfavored by Arizona courts. Litigants should not be using motions to strike as a substitute for a response. Regardless, the motion to strike does not address the substance of the Rule 11 motion at all. Again, as with the fee motion, any substantive arguments are therefore independently waived. But on top of that, plaintiffs' 4 arguments in the motion to strike fail. Somewhat incredibly, plaintiffs contend that there was no meet and confer. This is categorically false. As my declaration outlines, and plaintiffs well know, there have been meet and confer calls throughout this case with all of the various counsel that have appeared. But more to the point, both of the Rule 11 safe harbor letters informed plaintiffs that we believe sanctions may be in order, and they expressly requested a Rule 11C2A or 7.1H conferral call. Plaintiffs never responded to either of those letters. It wasn't that they responded too little or too late. They did not respond at all. To date, we have never received any kind of response to those letters. They also contend that those letters somehow were insufficient under Rule 11B. And this is hard to square with the letters themselves, which are incredibly detailed. They attach some 500 pages of supporting documentation. They are each captioned Rule 11 and ARS 12349 safe harbor letters. So they plainly satisfy any specificity requirement. And plaintiffs don't really explain how they don't. And then plaintiffs also contend that that this motion is untimely. They cite Britt v. Stephan, but that case found a Rule 11 motion timely when it was filed within months of the triggering ruling. Plaintiffs would have called an earlier motion premature, but again, more importantly, the court told us that the issue of fees, would be addressed after the rest of the claims were resolved. That hadn't happened until we asked the court in this set of filings to dismiss our remaining counterclaims. And then finally, they raised the scope of who may be sanctioned. And they question our pointing to specific counsel who were involved in the heavy lifting periods of time in the course of this case. That some of plaintiffs' former counsel already withdrew from this case doesn't insulate plaintiffs or their remaining counsel from responsibility for the conduct at issue. And particularly, we highlight Mr. Marhofer's conduct at the outset of the case, initiating these proceedings despite receiving a letter from my firm before this case was ever filed, indicating that such claims would be without merit. And Mr. Powers, who picked up that baton in October of 2025 and proceeded full steam ahead with the third amended complaint, despite all of our prior warnings.
Let me ask you about Mr. Marhofer. He pointed out in his response that he wasn't even served with the motion. I'm not sure why he's not here today. And I probably would need to go back and look at the minute entry and see if he was endorsed on it. Was he served with the Rule 11 motion? And can you address how it's appropriate to impose nearly $800,000 of Rule 11 sanctions on him, much of which was incurred long after he withdrew from the case?
Sure. And as far as the service, I know that he received the motion. He was on emails that were exchanged between Mr. Powers and I immediately following the filing of the motions. So I don't know exactly if he didn't receive them or not. But as far as I understand it, he had notice of those motions through the plaintiffs. And then as far as his involvement, so the heaviest lifting of this case was really that initial time period between the first two motions to dismiss and the receivership hearing, which, as you will recall, was a 2-day evidentiary hearing, in advance of which we took multiple depositions and took significant written discovery. So that period of time is a significant period of time in the case. And two things happened during that time. First, we sent him a letter before any lawsuit was filed, before any complaint was on file, indicating that the claims that he was trying to assert in a demand letter that he sent were without merit, and telling him at that time that if you proceed with these claims, we will pursue fees and sanctions against you. And then he also received that initial Rule 11 letter that we sent in August 2024.
Anything further?
On that point, no. I mean, I think the point of this is that how these sanctions should work is within the court's discretion. And so where the sanctions should be awarded as to Mr. Powers versus as to Mr. Marhofer versus as to the plaintiffs, that is within the court's discretion. Our point is this is the total amount of fees that should be awarded to the board defendants.
Hey,
So-
anything else? Go ahead.
So apart from the procedural issues that the plaintiffs identified in their motion to strike, none of which defeat the merits of the board defendants' motion, the board defendants have squarely met the requirements showing that sanctions are in order in this case. This is that extraordinary type of case where sanctions are appropriate. Rule 11B requires every pleading be well-grounded in fact and law. But here, each amended complaint repeated allegations already disproven by documentary evidence disclosed in the safe harbor letters. And this whole thing began with my firm informing Mr. Marhofer that his clients did not have viable claims against the board defendants, and we would pursue sanctions if suit was filed. But nothing has ever deterred these plaintiffs. And again, while Mr. Marhofer is no longer involved, no response was ever received to our Rule 11 letter. In August of 2024, we received no response. The plaintiffs just plowed forward. In March of 2024, we received no response. The plaintiffs again continued forward. We had to argue the motion to dismiss, which ultimately was decided in the board defendants' favor. So nothing has deterred these plaintiffs. Even that final dismissal order did not stop them from sending numerous emails and trying to use this briefing process, as they did in their response to the motion to dismiss, decided issues. This matters because by the second and third amended complaints, plaintiffs had actual notice, including that we provided them a signed board consent that directly contradicted their entire theory that there was some secret capital raise claim, and they repled anyway. And just to be really clear, we're not seeking double recovery here. This requested sanction is coextensive with, not in addition to, the fees and costs sought under the statutory fee motion. So it is that grand total of fees and costs incurred by these board defendants that we are requesting that the court award either as fees under the statutes or as a form of sanctions. And I do want to reiterate something, Your Honor, in closing. My clients are 4 individuals. These are not companies where litigation is a cost of doing business. They did not get paid to be on the board of Asator. They gain nothing from their involvement with this company except ultimately getting sued individually, which has amounted to 2 years of these harassing claims and legal fees. And these have given the plaintiffs every opportunity to put a stop to this. They have done exactly what should be expected of litigants in their position. They have told plaintiffs, they have shown plaintiffs that their claims are without merit. But plaintiffs have made it clear, and they're still making it clear in these filings, that they will not stop until the court puts an end to this and makes it right. So we're asking the court to, again, allow the defendants to walk away from their counterclaims as the court is permitting them to do, but also award the hundreds of thousands of dollars in fees that they have paid out of their own pockets in recognition of what the record already shows, that plaintiff's case lacked merit from day one and was maintained despite repeated documented warnings. And finally, to hold the plaintiffs and their counsel accountable for the cost of that choice. Plaintiffs' conduct in responding even to these motions, untimely, unresponsive to the merits, attempting to litigate via email, and regurgitating the same mischaracterizations of the record that have marked this case for 2 years, only reinforces why this is the type of case where this type of extraordinary relief, these types of sanctions are warranted. So we would ask the court to grant the 2 remaining motions and deny the motion to strike.
I do have one more question for you. Gallagher and Kennedy filed a response indicating that you've confirmed that you are not seeking an award of fees against Gallagher and Kennedy and Mr. Sheehan. Is that correct?
It is, Your Honor. What Gallagher and Kennedy was able to provide us with, which we did not have any indication of prior to this briefing process, was that Mr. Sheehan's and Gallagher and Kennedy's representation ended immediately after the receiver hearing. Our Rule 11 letter followed that hearing. They also were not involved at the original filing point when we had already sent letters to Mr. Marhofer, so they kind of fell into that in-between moment. They pursued the receivership by representing the plaintiffs at the hearing, but that was the extent of their involvement. And so they were able to confirm that they really fell outside of those kind of Rule 11 flag posts.
Okay, thank you. Mr. Powers.
Thank you, Your Honor. The first thing I want to do, because I don't want to regurgitate the record because I know that the court is familiar with it, but I have to state a few important background considerations, factual considerations. That is, one, when I came onto this in the fall of 25, September-ish, I was of the understanding from my client that rent had not been paid, or at least there were periods of time where rent had not been paid, and that is where the prototype and or IP is. So that was a major serious issue. And when we tried to inquire, or at least when my client tried to inquire about that, we couldn't get answers. So we were concerned about losing the prototype or the IP. Secondly, we were making requests for books and records of the entity, of the company, of defendants. We wanted books and records. And I said as much in the Rule 7.1 meet and confer I had with Ms. McCready, saying I would drop almost all of our claims, but we just needed books and records. Thirdly, the IP has been either transferred or expired on the prototype. So we had reasonable claims, not just on rent, but on books and records. And where's this IP? We still don't know where the IP is or who owns the IP because the defendants have lost it. Okay. So with those important considerations, plus it's been difficult to, communicate with my client who is sick. Going on to the motions for attorney's fees, our position is pretty simple, and that we believe that the motion for attorney's fees had to be within 20 days of the May 5th ruling. It was not. The motion, there are still counterclaims, and as a backup argument, the counterclaims are still.
I'm confused by that reading of Rule 54G, because I've looked at it. You quote the rule in your papers, and I pulled it up independently and looked at it. And because all claims had not been resolved, I don't think that time